Next up, we'll pull up the document numbering list. This is the broad explanation of our library as it stands. So when we created the forms library, we tried to break it down into somewhat thematic pieces. So the forms are a numerical period numerical process. Um, the first numerical before the period, so the major number that decides the type of form that we're dealing with. The secondary number is what it is in that major category. So for example, the 1 point such and such documents are purchase and sale agreements and things that modify the offer itself in a major way. So for example, a right of first refusal or a right of first offer. They're not technically part of the purchase and sale agreement, but they're material to kind of the offer process itself. So we put them in the same place. A letter of intent, in theory, it's the same kind of thing. It's not actually an offer, but it's almost an offer, and it's so integrally related to the offer process that we decided to put it in there. Escalation clause, same process. So in our purchase and sale agreement section, we have residential, commercial, manufactured home, and floating homes. So these are the titled objects that don't actually exist as real property in many cases. That document can also be used for those instances where you have a manufactured home that is on a space that is owned by the party. So you own the land underneath it and you own the manufactured home, but you haven't titled or fixed the property to the land. Same purchase and sale agreement works for that. Agricultural land PSA, that's our take on farm and ranch stuff. It is more broadly applicable than just agriculture. So that's ag, commercial agriculture, mineral extraction, solar farms, conservation, game hunting reserves and game reserves, that sort of thing. We didn't want to have a 60-word title that one, so it's just agricultural land purchase and sale agreement. Vacant land purchase and sale agreement, right of first refusal, right of first offer, letter of intent, escalation clause. The escalation clause we put in because there's been a major request for membership to have something like that. It's a reality of the field. So we're trying to meet those demands of the membership and provide the forms that people use. The 2 points are various addenda, the modifications to the forms and the responses. So counteroffer, general addenda, late acceptance. In this case, we wanted to have some sort of a process for responding to an offer after it expires. And so our late acceptance addendum is to do that. Essentially, buyer puts in their offer, they say it expires at 5 p.m. tomorrow, you don't respond. As a seller, you can still send that offer back to him with the late acceptance and say, hey, buyer, I recognize that I missed the deadline. However, would you still like to work with this offer? And the buyer then gets their option to say yes or no. It's possible the buyer had just moved on since their thing expired and they put an offer somewhere else and they don't want to proceed. But having a form to facilitate that late acceptance is something that we decided was necessary or important for the field. Bill of sale, repair addendum, lead-based hazards. This is the lead-based paint addendum. Federal law defines lead-based paint as essentially anything that is a lead-based hazard. So we just cut out the middleman and make it a lead-based hazard addendum. This means, so for example, we've had questions on the legal hotline, and I guess I'll back up a step. On the legal hotline, we get various questions about forms and various questions about interpretation of things. So we have sort of a finger on the vein of the field itself. We know roughly what realtors are struggling with in their transactions when they call us up and ask for help on these processes. And so, for example, in the past, we've gotten questions that say, lead-based paint inspection showed that there are lead pipes that are corroding and there's lead in the water. Can I still terminate because it's not lead-based paint, it's lead pipes? The federal law permits that. So we've made this form more applicable to the actual application as you use federal law or as you interpret federal law, rather than kind of this broad standard of there is lead-based paint, but you can also terminate for any reason. It's more distinct to the actual laws themselves. We've got FERPTA addendum. This is built into your purchase and sale agreement. This is kind of a belt and suspenders document. So if you really, really want to be clear on FERPTA, we have a form for that. Wells and septic, contingent rights to purchase, contingent rights to sell, wood stove addendum. That hasn't changed very much. It's Oregon law. Waiver of contingencies, release of contingencies. I'll highlight areas where we have made somewhat, not significant, but procedural changes to the way that practice is done. In this case, waiver and release is probably the first one to really point out. So as it stands, there's removal of contingencies and removal of rights is the way that the forms work. In a court of law, the question would kind of be, what do you mean by remove? What are you even doing with that? Because in a legal sense, you have your option of release or waiver. Waiver happens before you initiate a right, release happens after you initiate it. So for example, I haven't started my inspection, I can waive my right to that. I don't need to take on the right in any case. I've gotten rid of it before I even started it. On the other hand, I can release a right once I've started it and basically say I'm satisfied with whatever I've seen so far, I'm done here. It doesn't change the actual outcome of any of your transactions. The difference is this is a little more clarity for those cases where you do go into a court or a complaint with a client and they say, well, how do you, I said I released my right, but I'd already done the inspection, or I'd waived my right, but I already did the inspection, so how could I waive it? And we just want to bypass that argument of a client being able to say, I already did the inspection, so how can I possibly waive it? Now it's release instead. So we're trying to head off some arguments at the past that we do see on Legal Hotline periodically. We've got seller occupancy, buyer pre-closing occupancy addendum. So when the buyer moves in and then they buy the house afterwards. If you really want it, there's an attorney review addendum that lets you build in somewhat of a contingency that says, buyer or seller are going to have their attorney look at this. And if the attorney's not pleased with it, or if they're concerned about things, they have the right to terminate based on the attorney's review. This base form change. Oh, I'm sorry. Is there a question?
No, I just caught a breath.
Like an attorney is going to be okay with it.
Yeah, okay.
We got FHA amendatory clause. That is statutory language. It didn't change very much. The base form change request. That is, our stance is, even in the current sense on the legal hotline, is when someone gets a form that they don't understand, they should typically keep that transaction all on the same type of form. So for example, commercial transaction, realtor is given a form on a cab form, and they say, I don't know how cab forms work. We get calls periodically where they say, I got a cab form, I don't know how it works, what am I supposed to do? And the legal hotline's answer every time is, you either need to get educated on how cab forms work or request that this form, that the transaction be moved onto the form you understand. And that's the same, this form is meant to facilitate that, in particular because there will now be there'll be ORF forms and Oregon Realtors forms on the market. So if a party is not educated on these things, then we can say this form is to facilitate movement onto the form that you are comfortable with, you're educated on. With that said, all of our training on Oregon Realtors forms will be available to all realtors who are using them. So, you'll have an access point to learning about these tools if you do get someone that says, I have to use an Oregon Realtors form and you're not sure about how it works yet. The training is available, it's there. We also have the backup and offer addendum. That's meant to facilitate backup offers. In theory, the difference between the ORF1 and ours is this creates a potential for 2 backup offers. So rather than in the past where there's only 1 backup, we have a prioritization for 2 backups. We thought about going further into like 3rd, 4th, and 5th backups, but at that point we decided it's probably better to have a specialized addendum for a 3rd or a 4th or a 5th backup. But that should help facilitate these instances where you do have those multiple offers and a backup. The 3.0s are disclosure documents. We have the seller's property disclosure. We know you hate it. We apologize. We can't change it. It's statutory law. The agricultural land process and vacant land process, our interpretation of that is there are disclosures that should be made on those sort of transactions that aren't in the SPDS. So for example, in vacant land, not knowing whether or not the land has the potential to be hooked up to the water main. If it can be hooked up to the water main, that helps if you're trying to develop the property. And so that kind of a disclosure is valuable. And so there's just an additional kind of second belt and suspenders for those sort of transactions to facilitate additional disclosure. Our reasoning for that is we found that disclosure is probably the best tool a seller can ever use to protect themselves in a lawsuit, as long as it's done based on their own knowledge. So the seller shouldn't just be checking yes because they want to check a yes box. As long as they know the thing is true, they should check that and disclose it. And if they have disclosed information, it is almost always in the seller's best interest. It helps prevent lawsuits. It may not help them get offers accepted necessarily, but it will help transactions from turning into a lawsuit where someone has to deal with expensive attorneys at the end of it. And then we also have this attachment sheet for disclosures to help facilitate the actual attachment. When you check yes on one of the boxes and it's got the little asterisks, you're supposed to put in your survey or whatever it is. So we have a sheet to help facilitate that. The 4.0s are types of property, so various properties that this is just something, a state-based standard of what that property is. So is it a new construction? Is it being used as an investment property? Is it a historic property or in a historic district? Does it have an association like an HOA or a condominium association? You'll note that the condominium and the new construction, those were purchase and sale agreements in the ORF standard. while wandering through the documents, essentially our understanding and the task force's understanding when we created these is most of the information that is covered in those purchase and sale agreements is better addressed as an addendum. So rather than having a separate purchase and sale agreement, it is a residential property that is a new construction. So you'd have a residential purchase and sale agreement, and you would also have the new construction addendum for that. And so silence that. It covers all the same processes and all the same questions. It just separates it into an addendum so you don't have as many purchase and sale agreements to deal with. Once you get into the 5.0s, this is where we do our standard of practice changes a little bit. This is to make it more aligned with the actual current contract law, the standard of kind of common law contracts. Essentially, we're introducing the concept of a default. So the principle there is if you have a transaction, there are, for example, in your current ORF transactions, you'll have certain provisions that say buyer will keep seller informed of all material changes to their loan documents, something like that. It doesn't necessarily tell you if you can terminate or not. There are other times where the document very distinctly tells you can terminate. So for example, buyer can terminate at any point within the inspection period. You know absolutely that you can terminate within those periods. At contract law, the way that we typically look at this is if it's something that tells you can terminate, it's a very material problem. It's a material issue that you should be allowed to terminate for. If it doesn't tell you can terminate, it might be something that's a minor problem, and those minor problems are what are considered immaterial defaults. They're problems. Someone's violated their obligations, but they haven't violated it in a way that torpedoes the contract. And so the notice of default is all of these minor things. Hey buyer, you told me you were going to give me notice of this thing and you haven't yet. Those little requests that you would make. There's now a form that has all of them kind of in a checkbox list that lets you select it and say, buyer, here are the things you were supposed to do. You have 3 days to fix it. You were supposed to have done it by Wednesday. You now have until Monday next week. If you get it to me on Monday, great. We can keep going with the transaction. If you don't, I now have a cause of action to terminate the transaction, to terminate this contract. The reasoning why we've done it this way is on the legal hotline, termination is a constant problem that people are not confused by, but the process itself is somewhat confusing. And so we're trying to streamline it, have instances where you can say, here's notice, fix this thing, please. If you don't fix it, we're done. I terminate and I get to take the earnest money with me. Or, if they fix it, you can keep going with your transaction. It's great. And we have the buyers and the sellers notices of default. We've trolled the documents for every single instance that we believe is a default, and those are noted on these documents. So if you have a reason for terminating or for defaulting, there should be a checkbox for that, which then clears up some of the problems of having to write in the box, kind of cross your fingers and hope you've said the right thing to make that termination valid. When you get to termination itself, we have a buyer's notice of termination, a seller's notice of termination, and a response to termination that comes from the opposite party. This is because the way termination is supposed to work at contract law is when a party terminates, the contract is over. You don't have to agree to your termination. And that's the way it currently works, but we constantly get questions on the legal hotline that say, my seller wants to terminate, but the buyer refuses to sign the termination agreement. What am I supposed to do? And the legal answer is, well, once you've signed the termination document and you've decided to terminate, you've told the other party to terminate, the contract is done. You've terminated, with the exception of if a seller is terminating, the buyer still has the potential of claiming specific performance. And so we've broken the termination documents into buyer and seller termination, and then the response, which provides escrow instructions, essentially. And then the termination itself, if you're a seller and you're terminating, it says, hey, by the way, just so you know, the buyer still has the potential to claim specific performance. So, stay tuned. Don't sell the house to somebody else just yet until the buyer releases their specific performance claims. If they release it, congratulations, move forward. If they don't release it, now the parties are at least fully appraised of exactly what the process is and how they stand in the contractual world. And the seller shouldn't sell the house to someone else, because then you get into the problem of getting specific performance when a house has already been sold to a bona fide purchaser of value. And we just don't want to go there because it creates a legal quagmire. So these forms are supposed to kind of prevent these termination problems that arise with not regularity, but with passing regularity in the real estate field. The 6.0s, 5.7, seller's property disclosure, there's a revocation. That one's special because if you revoke, it's the one of the few instances where escrow doesn't need identical instructions. The reason why we have a notice of termination and a response to termination is because of escrow. When you put your money in escrow and you don't have identical instructions for where the money goes when you've terminated your transaction, escrow clams up and the money gets locked in there until you figure out where it's supposed to go. The exception is the SPDS. If you revoke, the money doesn't have to be identically directed out. Instead, the buyer just gets the money back because they can say, I revoke based on the SPDS. So that form has to be there just kind of facilitate that sort of revocation. For commercial, there are those special instances where commercial leases need to be assigned and commercial processes have more due diligence documents that are requested at times. So we have forms to facilitate that. The 7.0s are those tenant-related processes. So if you have tenant-occupied property and you need that tenant out by closure, so you need a vacancy by the time you move in, this form facilitates that. We have a tenant estoppel certificate that's supposed to help kind of be, it's been a request from the membership that we get estoppel certificates because it lets you kind of bind the tenant to their word and you don't have as many of those I was told this was the case kind of problems after the fact. If you have leased or financed equipment, propane tank, solar panel, something along those lines, those are specialized processes for transferring that because you have to assign that lease if you're going to be moving it along. Otherwise, you want to get it removed or something along those lines. This form facilitates that movement of a leased solar panel or a leased propane tank. And agricultural tenants have their own special thing with emblements. So we have a special form for agricultural tenants to ensure that that emblement protection still exists. You can go onto the land and collect your crops if you planted it. And so that form is specialized to agriculture. If you're doing seller carried stuff, we still advise as a legal hotline to not do seller carried, but it's a reality of the field. So we need to have documents to help facilitate that in a relatively safe way. This is the seller carried section, 8.0. So you have a seller carried addendum that essentially provides additional protections and disclosures. And for example, like credit check, the ability for the seller to do a credit check on the buyer if they're going to be giving a promissory note off. We have the promissory note, deed of trust, land sale contract, and memorandum of land sale contract. These forms are cabined in. They are not as freewheeling as the previous seller carried documents, and that's intentional because, for example, on a promissory note, if you put your interest rate at 0%, you're probably violating federal tax law. You've gone below the minimum applicable federal rate. If you go above 9%, you could be violating Oregon usury law. So we've cabined in the ability to put interest at extreme highs or extreme lows just to prevent those possibilities of being in a legal quandary because of just a buyer saying, I don't want to charge interest. You kind of have to, otherwise you violate the law very quickly and very easily. And so the forms are less open than your previous seller carry transaction forms, but the intention behind that closedness in those forms is that it protects you on a legal level. It protects your client on a legal level, and it also starts off saying, hey, our realtors are only scriveners. They are only doing what you tell them to do. So we're trying to sort of put a paper shield around you with any seller carried transaction. The 9.0s are all your agency related documents. We have final agency acknowledgement, disclosed limited agency. We have a listing agreement. We're trying to get it checked over with the MLSs so that they'll approve of it, but many of them are on board with the idea of having a centralized sort of state provided listing agreement rather than having the 12 or 13 or so kind of separate agreements that exist out in the world that each one might be somewhat different depending on which listing service you're using. We're getting pretty good response on this being a state form, so stay tuned. We're pretty confident that this will be the case, but at present we haven't had a full buy-in from every single MLS. The buyer's representation agreement, buyer's non-agency, and seller's non-agency agreement. So those are if you have a for sale by owner or an unrepresented buyer. We have forms to facilitate that. The ones that say, hey, buyer, the seller's agent is not your agent. You can't sue and say, well, this guy was totally my agent and he owed me all these obligations and protections. This form facilitates it in the same way that you have in the past for these non-represented parties. We also have a conflict of interests form, and the reason for that is it does come up quite regularly on Legal Hotline where someone asks, hey, how does conflict of interests work? I know this might be one, but what do I need to do? And this form is meant to kind of clear up the questions about conflict of interest and give a very distinct kind of statutory language that explains exactly when you have a conflict of interest and how to disclose it and to facilitate that disclosure. Notice of real estate compensation, it's the statutory language form. We didn't change it all that much just because you kind of can't. And then lastly, we have our advisories. So the 10 points are the advisories. It's buyer, seller, the lead-based pamphlet that comes from the EPA, and the initial agency disclosure pamphlet that comes from the Oregon Real Estate Agency. Our buyer and seller advisory are required provisions. It's something in all the purchase and sale agreements. We say, hey, buyer, hey, seller, you should have received an advisory and you should have read it. And we've drummed those up to kind of cover all the new things that exist in our contract. So the process of default and things like that is now part of those advisories. And the idea of the advisory is to, for any of the language where a buyer might go, hey, how does this work? They'll be able to consult that advisory and have that information provided to them. They'll be able to understand exactly the processes that are being used in this transaction. That was about a 60-mile-an-hour definition of the entire library. Do we have questions at this stage? Yeah.
I do have one. I noticed, so the way that standard practice has been with the contract we've had for the last 7 years is that, you know, the actual time, delivery is, the transmission is proof of delivery in the time, correct?
Contracts in general or for the seller's property?
Well, no, our sales agreement we've been using for the last like 7 years.
Sure.
So standard practice has been that you keep a copy of transmittal to prove, you know, when you sent it is actually, the delivery date is different than the signing date, right? Or time, I should say time. I noticed in your contract, you're not really addressing it quite the same way. It's a lot more, I don't know, I mean, I've never liked the whole transmittal idea, but it is what we've been practicing. And I notice it's not addressed as much in this contract.
Now, are you talking about the statutory property disclosure statement or
Sales
everything?
contract, so the same
Everything.
contract.
Okay. Yeah.
So-
So we define the mutual acceptance of the contract to be when the both parties have signed the agreement and delivered it to each other. So
Right.
it is based upon delivery. If you've got a signed document sitting there that's never delivered, it's not going to be an effective contract. And the delivery time, the best evidence of delivery time would be the moment that the email was sent, to the other party. So you're saying that we don't spell that out clearly enough?
That's been how it's been, and it's very clear in the current ORF thing of what that means, that you have to have proof of transmittal. And it's not as clear in this one. I don't really care, but I just know that currently the standard practice is you keep a copy of that transmittal. That's because that's your proof of delivery. And it's notes that kind of in your document, and we require it as part of our CYA and checking other documents, but it's not as clear in this one. So
Got it. Well, the standard is the same, and we'll look through the document to see if we can make it clearer. But we're not changing
I
any
don't care that you
standard.
need to make it clearer. I just think that when you guys present it, if the standard hasn't changed, maybe that's a comment also from the real estate agency that it's still proof of that is going to be required. So I don't know that you need to change the contract. I just think you need to, because if I didn't see that, I mean, I would wonder if it's gone. I understand what you're saying, but we have other offices and people we work with. That's all.
Yeah.
Does that make sense?
Yeah. No, thanks for that feedback. Now, just to follow up on that, though, we do have, I think you're talking about just generally sending any document to someone and having proof of when it was sent.
Mhm.
We do have a separate section as well in the sale agreement to specifically notate that you presented, like if you're a seller's agent, that you presented the offer to your seller. So that we do have that in there as well as just an extra opportunity to document that for if your files get audited.
Right.
Yeah.
I just know myself that, like, when I would broker contracts, I look at the transmittal, and if it's past the date of what was written on the contract, I always tell my agents, you either have to get an addendum to make sure everyone agrees to that, or take your chances that someone's gonna dispute it.
Yep.
And so the way, and that may be the way we still do it, but it's not as clear in this. They made it in big bold and ORF, that so you can't really argue with it. I mean, I've pointed it out 100 times. That's why I'm saying I'm okay either way. I just was noting that.
Thank you.
Are we gonna go over any of the forms? Are you guys gonna show us some of the forms?
Yeah, our thought was to go over the purchase and sale agreement, the 1.1 residential purchase and sale agreement. If there are other forms you would like to see more, then speak now or forever hold your peace.
The other one, I would probably say, I like the residential one, and then one, the SPDS, the termination form, that new one that you have.
Oh, the revocation of offer.
Yeah, so after the residential one, that would be nice to go over too.
It'll probably be easiest to start on the purchase and sale agreement one. This is, it's a one pager, so it's a pretty fast description. So this is for revocation based on the seller's property disclosure form. Essentially, it begins with saying, "Hey, buyer, you have a right to revoke your offer unless you've waived it or somehow claimed an exclusion has been claimed." In this case, you have 5 business days after the offer is delivered. After the SPDS is delivered to the buyer or the buyer's agent, you have 5 business days to revoke the offer. We've modified that in the meantime to also include or after mutual acceptance. So it's 5 days after mutual acceptance to revoke, which is similar to the standard that currently exists. If the seller doesn't provide the SPDS, you have an unlimited time frame to do this revocation. Escrow instructions, it says, "Hey buyer, if you revoke and it's valid under the SPDS, the escrow doesn't need identical instructions. They will dispense earnest money." Then you provide exactly when the SPDS was delivered. You say the date and the time, or you say it was never delivered to kind of buttress your argument for escrow to say, "Yes, I am requesting this within 5 days. You know, I can show that this was delivered on the following day." You state the reason why you're revoking. Either you disapprove of the statutory disclosure statement within 5 days after it was delivered, or it was never released to you and you're still disapproving of whatever it is, or you're disapproving of the failure to provide it. And then instructions to escrow are what they are, and you give the escrow title company and the escrow number, and that should facilitate the transfer or the disbursement of that earnest money after a revocation.
Can you see the top again?
Yep.
Please? Okay. So this doesn't have to be, this is given when they're gonna terminate, not at the beginning of the contract.
Yeah, this is something that the seller would essentially, or I guess the buyer would send in when they're revoking their offer. So this is the response that the buyer gives that terminates. It's one of the documents that will terminate the transaction.
And this is just for this is just for a failure related to the seller property disclosure statement.
Right.
It has a special place in Oregon law because it's a revocation of a contract, which is something that normally isn't supposed to happen. You normally would terminate, and then there would be a very distinct process. But in this one case, by statute, you're allowed to revoke and kind of void the contract ab initio, which is not supposed to normally occur.
Okay. Thank you. Any questions on that form?
No,
I think we're good.
thank you.
Okay, so we'll hop into the residential purchase and sale agreement. This is kind of the meat and potatoes document that most people have been looking through. It starts with a page 1 final agency acknowledgement. We have more space for the buyer's agent and the seller's agents here because and we wanted there to be enough space for at least these teams that are showing up that have 2 or 3 agents that are part of a transaction. The first page is just that final agency acknowledgement, same in all the purchase and sale agreements. The actual first page of the real agreement itself is technically page 2 of the PDF, but it's page 1 of your purchase and sale agreement. So final agency acknowledgement, and then everything after that is the purchase and sale agreement. On the residential purchase and sale agreement, the way that we've organized this document is intentionally from the most malleable to the least malleable provisions in the contract. So the first page has all of the provisions that you're going to be writing in distinct things. You'll be changing the purchase price. You'll be writing in the property address. You'll be writing in the parties' names. You'll say whether or not you have tenants. The major questions of the transaction occur on the first page. In theory, this is the material terms. It's very similar to some, for example, a summary or whatever the broad, concise summary thing that you have in OREF right now that says, how much does it cost? When do I close? How much is the down payment? That sort of thing. That's all on your first page. We've added a section here for down payment. That was a request by the membership. We had removed it earlier at the task force that we talked with said, well, we don't know if it's necessarily going to be that important to have that there. It's been requested by membership. So down payments back in. We just haven't updated the document on the website yet because it breaks all the links. But there's now down payment in this. So you'll see on the first page, you have very broad fill-in terms. What kind of loan are you doing? Are you using non-liquid funds? If you're using cryptocurrency, you should tell them that because it might not exist tomorrow. So those are things that you need to sort of specify at the start of the transaction if you're using them.
That was funny.
I call it pawn.
Question?
No, just the Bitcoin. I got Gail's reaction. I thought that was funny.
I call it Bitcon, CON.
Fair. It's better than an NFT though. I mean, those are even harder to translate.
Huh.
We've got various other check boxes. So in these, you'll note if you ever check yes, it says, form 4.1 for a new construction. That's a new construction addendum. So if you check yes and it says form such and such afterwards, you're supposed to attach that form. We're working with the technology to try and get those automatically attached to these. If you're filling it out in the software and you check the yes box, it will add that form to the end of your digital document for the transaction. We'd like that to be the case. We're trying to get it to happen, but it might be just a limitation of the technology itself that decides whether that happens. But we would love for that to occur, and stay tuned. It might is the best answer we have on that. So this first page just kind of reiterate all of the really kind of malleable terms, the yes, nos, the big things that will modify a transaction, and the major things a party's going to be asking about. How much does it cost? When do I close? That sort of stuff. Page 2, 3, and 4 are the less malleable. You don't modify these as much, but you still have some flexibility in what you can do, the time frames. So for example, earnest money, you can say the default of 3 business days, or you can write in a different number. It might be 60 business days to do earnest money if you've got one of those transactions going on. So you have the ability to make choices in these 2, 3, 4 pages, the second, third, and fourth page, but you're not modifying as much. So as you move down the contract, it goes from most changeable, most kind of input involved to least input involved as we go down the contract. It'll be more clear as I get to the third chunk of it as well. You'll note that we have a checkbox for 3 business days and a blank, but it does not have a default number of business days. That is a risk management decision. We still have this just because people make mistakes into error as human, we have specific dates control. If neither box or if both boxes are checked, one does control. So there is still the more specific first term is always the default. But as a risk management kind of tip, always check the default, or like write in the number that you want to be the number of days involved in something. The reason for that is, imagine you and a client have a dispute about earnest money. The client says, I thought I had 5 business days, and you said, no, we decided on 3 business days. And the client goes to the arbitrator and says, well, they didn't write anything in. My agent is incompetent. And your response is, I didn't write anything in because it was the default date. You now have to, it's purely based on the arguments of who do we trust more, who does the arbitrator trust more. If you can check that box, it's one more click button. That's all it takes, and it protects you in those lawsuits from being the argument is no longer makeable that my agent is incompetent because they didn't write the thing in. You now have the ability to say, I very affirmatively made a decision to click that box. We chose 3 days. It's obvious that we made that decision. I didn't just miss it. I didn't jump over that box. One thing to note in this section as well, and I'm sorry, I'm kind of bouncing about as we're wandering into the document. Earnest money deposit, we do have a slight change on the standard of practice for how things are done. We think this is a better approach to how Oregon does earnest money deposits. Essentially, when earnest money deposit is supposed to happen, what do you do when the buyer doesn't provide the earnest money? That has been a question that bedevils people on the hotline periodically. There is no money in escrow. What am I supposed to do? Do I need to do a termination agreement and send them the escrow instructions even though escrow has no money? Like, what am I even supposed to do here? So we decided, let's bifurcate it. There are 2 options now. If the seller wants to terminate and just be done with it and ignore the potential of getting the earnest money out of the buyer, they can just send a termination. It's over. Nobody gets earnest money. It's done. You just proceed to the next buyer. Or the seller can send a default and say, hey, buyer, you were supposed to send the earnest money in. You didn't. Please send it in. And if you don't send it in, I am going to be able to pursue, the contract allows me to pursue action against you to collect that earnest money. So we've built in essentially a 2-way street for the seller to choose. Do you cut now and move to your next buyer in a hot market? Or do you tell the buyer, you have 3 more days. If you don't, I will come after you for the earnest money, and I have a cause of action written into the contract. And so it provides an additional kind of choice and protection for the sellers. We think this is a nice kind of compromise for the way that sellers want to work in these transactions and in these markets. All of these provisions that you have for timelines, they generally will have business days or calendar days. It will specifically tell you if it's business or calendar days. There should be no instances where this transaction just says days. And that's because days is a very broad term in Oregon when we use calendar and business days. Now, you'll note most of these say business days. The reason for that is business days are kind of the preferred standard. With that said, lead-based hazards, lead-based paint, where is it? There we go. We had to do calendar. We didn't have to. We did calendar days because that's the federal standard. We kicked back and forth the idea of changing that to 10 business days, which would in theory be potentially up to 14 calendar days. But we decided that this would be something that if we're going to make a change to the federal standard, we want the membership to ask us to do it. We don't want to just be kind of forcing that on you. So we have had questions kind of in the feedback that we've gotten since this soft launch that says, why don't we just do all business days? Calendar days are dumb. And our answer is, that's a great comment. If a lot of you want it, we can make that change, but we just didn't want to kind of force it upon you and be the people that changed the way you interpret federal law because, the lawyers said so. So that's it. Does have calendar days in the transaction, but not many, and it will tell you specifically when you're doing calendar versus business days. One other change to the practice that we're doing here: due diligence contingency rather than inspection contingency. So the standard at present is I have 10 days to get an inspection and terminate for any reason as long as I got that inspection. People look into houses for various other reasons. They might want a short-term rental, and it turns out on the coast you're not allowed to do that in this city, or something along those lines. And so the person, a buyer, may look into the property and say, well, zoning doesn't let me do what I want to do, so I need to terminate. And they get an inspection and then terminate for no reason that the inspection brings up, but just because they had an inspection during the inspection period. Their termination actual reason was something altogether different from the inspection. So what it is now is we just say, let's be honest about it. You have 10 days, look into the property. If you like it, great. If you don't like it, then terminate. But it doesn't have to be for this kind of a Trojan horse inspection process that we have currently. So it's just due diligence. If you're a buyer's agent, this broadens your ability to claim a termination within the first 10 days. In actuality, in reality, it just means the buyer doesn't have to buy an inspection to terminate for exactly that reason. We hope people like that, but again, we're open to.
Yeah.
Thumbs up.
Since we're doing a soft launch, we're liable to change anything if the membership requests it or wants it. This is where we're kind of asking people for their feedback, and if enough people are saying the same thing, we'll make those changes for sure. And so there are instances where, for example, our SPDS process, we had it originally as exactly what the federal or the statutory law at state level says, which is upon delivery of the document, you have 5 business days, but the industry seems to want 5 business days after mutual acceptance. So we're modifying our document to mimic the industry's request rather than just what the statutory language says exactly. Question from Gail.
So I see in the by the business day following the expiration of the due diligence period really is all financing in there, instead of like the inspection kind of moment. I don't see anything in there about what you said about the inspection. I see it's all about financing and appraisal.
Unless waived by
So
buyer.
Section 27,
27.
there's the financing above, and then below you talked about due diligence versus inspection period. But I see most of the verbiage in there is financing related.
Yeah, so section 27 is for financing. Section 30 is for the due diligence period. The financing thing, that following the expiration of the due diligence period, that's based on when you get your appraisal. This is one of those instances where we've broken a standard of kind of legal nomenclature in that we didn't define due diligence period until section 30. And the reason for that is defining due diligence period would be a pretty hefty, it's a large description in the due diligence period section. And we didn't want to necessarily input that in the financing section just to say, okay, so here's what due diligence is. Now you've got the full definition of it, and this is the due diligence period. And once that ends, or within 10 business days, if you don't have a due diligence period, that's when you need to get your appraisal. So we just kind of coalesced all the due diligence stuff into the due diligence section in section 30. But you're right, it's referenced in section 37. And that was a decision that I'll admit that was me doing that and just saying, I don't know if I want to put the giant description of diligence earlier in the contract in a point where it kind of disrupts the flow of that section. But if you are curious about due diligence, section 30 is where we cover all that in detail. And it essentially says, you still have a right to inspections. You can still do your inspections. There are things that are permitted. Radon is allowed. You can do a radon test. That's allowed, but it's one of many tools that you have as a buyer to look into the property. The standard for terminating based on the inspection being poor or whatever it ends up being is the same as it is currently. You just send in your termination and it's over. Title reports. This is one thing that has somewhat modified, and it's just as a result of kind of the industry and the hotline questions that pop up. periodically you will have amended title reports that get sent in. And the question is, what does that do? Because your title inspection period, the title review section, normally is 5 business days after you receive that preliminary title report. Well, what happens in those instances where title sends you a mea culpa email that says, hey, sorry, we found out there's a major easement on this property that we forgot the first time. Here it is. And they send this to you 15 days into the transaction. We had these problems come up on Legal Hotline. And our answer to it is the buyer gets another 5 days to review only these new things in the amended title report. So it's 5 business days for every individual instance of new thing in a title report. You get 5 days to look at it. And if you object, they get 5 days to fix it. And if they don't fix it, you get some time to terminate afterwards because they didn't fix that title report problem. But we now have a process to facilitate those amended title report instances where the title company drops the ball. You'll note as you move through the contract, you get less and less choice on these things. These terms, risk of loss, lead-based hazard, smoke alarms, statutory disclosure statement, that sort of thing, they're just standards at statutory law. They don't really modify very much. So these are still time frame related terms. So on page 234, all of your timelines are on those sections. But as you move down the document, you get to the less changeable sections of the timeline provisions. So, for example, lead-based hazard, you have 10 business calendar days. You can modify that, but you have to modify it on your actual agreement to do a lead-based hazard. So you'll have a separate form if you do really want to modify that. It's permitted at federal law, but we don't have a process for that in this section. It's pretty set in stone unless you really want to go outside that. Seller's property disclosure statement, you get 5 days. That isn't really modifiable. The statute doesn't let you modify it. It lets you waive it, but it doesn't really let you modify that 5-day standard. And so we're getting into the more kind of set in stone provisions as we work our way through the contract. Then we get to the general terms. These are all of the things that we would add. They're not boilerplate, but they're the provisions that we say, please don't change this because you'd be practicing law and that's a problem. So as you get to the bottom of page 4, page 5, page 6, and so on into page 9, these are the terms that you don't really change. They're protections of the contract, they're representations of a seller, they're acknowledgement that you're buying the property as is, where is. It's a description of FERPTA saying that escrow is going to take the lead on this one as the qualified substitute. It's allocation of who pays for what. It's descriptions of the closing costs, things that you aren't really going to shift because the contract has set it up. If it lets you shift it, it'll say you can also modify this with a general addendum, but it'll tell you to do it in a general addendum. And that's because you don't want to change these provisions often, and changing them can sometimes be seen as practice of law. You'll note in these sections where there is a separate obligation that the buyer has and the seller has, we have severed those. So if your buyer's wondering, what do I have to pay at closing? Well, you go down to 46, closing costs. See that section says buyer shall pay at or before closing? That's what you pay buyer. It's kind of put in a packaged box and gift wrapped for them right there as exactly their obligations written in a bold and italicized section for what they need to do. Let's see, closing, deed, curable default. Once you get into the section 49, 50, and 51, these are the death of the contract provisions. So what do you do to terminate a transaction? What do you do with the default? How do you terminate? How do you move forward in those cases? It's roughly how we described it. If there's a default, you tell them, you say, hey, you were supposed to do this thing. You have 3 days, please do the thing. And if they do the thing, you keep going. If they don't do the thing, well, you get to terminate at that point. And you have a very clear argument that can be made in arbitration or mediation that says, I gave them 3 extra days and I told them exactly what they had to do and they didn't. So I would like the earnest money. And most of the time the arbitrator will read the contract and say, exactly, I agree with you. And so we're giving a clear pathway for the output, the end of the transaction. There are defaults that, they're little things. It's a seller needs to, buyer needs to give notice to seller within 3 business days after something happens. If that goes past the closing date, we're not going to require you to have like a 3-day cure period. That's just a default. You can just, a termination. You can just say, all right, it's an immediate default. We butted up against the closing date. We don't need to give them a cure period. We're just ending the transaction because you didn't do what you were supposed to. Then we get into termination, roughly what we were talking about. If there are things that say you can terminate, you can terminate. If there's a default, you say, please fix this. If they don't fix it, you can terminate. If there's a property disclosure problem, you can revoke. That's its own thing. It's also in this section. But essentially, this provides you with the pathway of how you are supposed to end a transaction. Every time you give one of these notice of terminations, the other party has 2 days to provide you the response. The response and the notice, when you put them together, it works like the Wonder Twins, and it creates an escrow instruction that you get to actually like do something with. So if you have an identical notice of termination and response to termination, escrow has their instructions and you can move on to the next step. If you disagree with each other, it's the exact same process you currently have. Take it to small claims court or take it to mediation or arbitration. We'll tell you where earnest money goes. I'll pull up one of the termination documents after I get through this one just to show you that we've hopefully added a little more clarity to the direction that earnest money takes. This is generally going to be something that you'll always be able to kind of follow the process in the same direction. You know, when the buyer terminates during the inspection period, we know where the earnest money goes. And so it's very distinct pathways for earnest money, much in the same way that you currently send earnest money based on the contracts. Mandatory statement, we had to put it in there. State law, didn't change that. And then I would argue these are the boilerplates. The assignment, the obligation surviving death, time is of the essence, severability. If a piece of this gets made illegal by Oregon law, the legislature says, for example, you can't do non-liquid funds anymore. We're just going to say, cut that chunk out, line item veto. That piece doesn't work, but the rest of the contract still stays valid. This is standard in a legal contract. Non-waiver, entire agreement. If you modify things, you need to agree to it in writing with the other party, and then you can do it in counterparts, which lets you essentially do like DocuSign or sending multiple documents out into the world at once to get signed. The buyer then says when they want this offer to be accepted by, they put their expiration date. They say, expires at 3 p.m. On June 20th or whatever it ends up being. The seller gets to respond. They either accept, reject, or they counteroffer. If they counteroffer, we have a form for that. It's not super exciting. It just says I counteroffer and here's what my counteroffer terms are, but it's something to facilitate that counter. If the seller wants to accept a late offer after it's expired, you got the late offer acceptance addendum. That is then flipping the script, and then the buyer gets to make the decision on whether or not they want to move forward. We also have this little chunk here that lets you say when you presented your offer. So the presentment section. So if you're a seller's agent, you can say, I delivered this offer at this time. So I can show in that ethics dispute or whatever it is that I did present my offer. I'm going to pull up document 5.3. This is the notice of termination. So notice of termination, this is the buyer's notice. This is essentially when the buyer wants to terminate a transaction, they will send this document to the seller. So 5.3 is for the buyer, 5.4 is for the seller. When the seller is terminating, they send 5.4. When the buyer is terminating, they send 5.3. In 5.3, it has these various provisions such as section 3, instructions, and use of the notice. It tells you how it's supposed to be used. This is used when the buyer wants to end a sales transaction. They'll do this by stating the exact reason why they can terminate. This termination should have every specific reason you're using. The buyer acknowledges that they're not relying on their agent when they're telling about whether or not they're authorized to terminate the transaction. Termination is something the buyer has to make as their own decision. The agent shouldn't be kind of advising them one way or the other on whether or not it's the right choice to terminate or the wrong choice to terminate. That's for the buyer. They should seek out an attorney if they really want an answer on the legality of that termination or not. Section 4, you'll say exactly what you're terminating. You say exactly a sales agreement number. So I am terminating sales agreement ABC123, and then all the addenda with it get terminated alongside that. Upon delivery of a signed notice of termination, you have terminated your transaction. The other party doesn't need to sign it. Once you deliver the signed notice, that your buyer signs it and delivers it, you have now terminated the transaction. That's the way contract law is supposed to work. It's the way Grandpa intended it, and it's the way we do too. The response to termination, they have 2 business days to respond. This response to termination will essentially provide releases. If the buyer says, look, I don't want to pursue specific performance, let's just be done with this thing and get the earnest money figured out, they can release the right to the specific performance and then move forward. If the seller is giving a release to the response to the termination, they provide their escrow instructions, and alongside that response, they also say, buyer, I release you of your obligation to purchase this property. You don't have to buy it anymore. And the parties can just move forward at that stage. Section 6 is the escrow process. It essentially says the same thing that the purchase and sale agreement does, which is you need identical instructions. If you don't have identical instructions, we don't pass the money out. We hold it until we figure out who it gets to go to, or until a court tells us where it goes. And this is just kind of explaining that process. So you'll have section 6 to explain to your client if they are wanting to terminate. You can say, okay, and they say, hey, how does escrow work? Do I get my earnest money back? You can say, check out section 6. Escrow requires identical instructions. So if you agree where the money goes and the seller agrees where the money goes, great. Then the earnest money will be dispersed. But if not, we're going to have a problem that has to go to dispute resolution. Section 7, this is the actual like real section of this termination agreement. It tells you what the termination does and for what reason and how it works. Essentially, it says, buyer, you acknowledge that you are terminating, and if you do it wrong, you may be in trouble because you've terminated for no good reason and you need a reason to terminate, but here are the reasons and the way escrow money moves if you do terminate. So section A of section 7A, earnest money is returned to the buyer if buyer's not in default. So for example, you check the box that say, I don't intend to continue the transaction after all or a part of the property is destroyed. That's part of the risk of loss provision in the purchase and sale agreement, which says, look, if the property gets hit by a meteorite, the buyer gets to choose whether or not they keep going or not. And the buyer can just say, look, this isn't worth it anymore. I don't want to buy a crater. And that's fine. So the buyer would then turn in this termination notice to the seller, and they'd say, seller, here's the notice of termination. I'm writing in which sales agreement we're terminating, and I'm checking the box that says I do not intend to continue the transaction because all or part of it was destroyed. So we're done here. And because he checked the box in section A, it says earnest money goes back to the buyer if they're not in default. So you have a very clear pathway for earnest money. That it doesn't mean the earnest money will always go that way because they still has to be identical escrow instructions, but you'll know where earnest money is supposed to be. So for example, if the buyer terminates for the section B reason, they receive a notice of default, an opportunity to cure, and they don't wish to cure the default. The buyer says, fine, I terminate because it lets me terminate. They need to understand that they might be forfeiting their earnest money because they're deciding not to cure something they're already in default over. We do have section 8, which is for other reasons. So if there is something that is not written into the purchase and sale agreement, you can put that in there. You can say, buyer terminates because it's Tuesday, but you might be losing your earnest money because you're terminating for a reason that is not valid under the contract. So, and that's just how contract law works. If you have a contract and you bind yourself to your word and your promise, and then you terminate for no good reason, there are penalties involved. And in this case, the penalty that's agreed to in this transaction is typically the earnest money. So if the buyer terminates for other reason, and it turns out that other reason was not valid, they might be losing their earnest money, and they need to understand that. So it's bolded and explained in section 8 of this document. They have their instructions to escrow where they say, here's where the money goes, here's where it goes to, here's the escrow company, here's the officer I was working with, here's the escrow number. And if that 9 through 12 section is identical as the one that's in the response to termination, escrow moves forward and it's great. If they're different, if the buyer says all the earnest money goes to me and the seller says all the earnest money goes to me, then you have a problem that has to be mediated or resolved in dispute resolution of some kind.